And as the Rahul disqualification storm rages on, my colleague Shreya Dhondial spoke to former Attorney General of India, Mukul Rohatagi, on what this means for the Congress leader. Listen in to this exclusive conversation.
I'm putting to India's most distinguished legal eagle, Mr. Mukul Rohatagi, who is joining us on the broadcast. He's also been a former Attorney General. Mr. Rohatagi, first of all, thank you very much for your time here on Mirror Now. Mr. Rohatagi, a lot has been said about Rahul Gandhi's sentencing and his disqualification. Can you help our viewers understand how a rhetorical speech made from a political stage has ended up suspending an MP for 6 years? I mean, politicians say the darnest things all the time. By that yardstick, 30% of our MPs would have to be suspended.
On the first question, I've heard you for the last 5 minutes, and people seem to think that the action of the Secretary General of Lok Sabha was rather prompt and very fast and all that, and therefore they should have waited and all that. Let me make one thing very clear. The law does not require the Secretary General to issue any order at all. The moment a conviction is recorded by a court, disqualification takes effect automatically the next second, not even the next minute. So it was not necessary for the Lok Sabha to issue any order. Whether they did it today, tomorrow, day after, it is of no consequence because the disqualification has attached itself to the membership of Mr. Rahul Gandhi. That's the first step. Let's be clear. Do not accuse the Secretary General or any other office in Lok Sabha because that was wholly unnecessary. Now that is the law. You can say that the law is unreasonable, but the facts show that when some respite was to be given from such an immediate disqualification, Mr. Gandhi himself tore up the amendment which was sought 10 years ago. So, well, then that's the law. It applies to everybody. Now let's look at the question you asked. Well, my answer is this, that this is the law. This has been the law from 1860 as to what is defamation. And the law of disqualification has been there for years and years. Everybody knows the law, and more so the politicians. And if you ask me, I have been watching, and you have been watching, and the public has been watching, the new law which has reached in all the legislative assemblies and parliament and municipal corporations as to how the law makers are behaving. They're throwing things at each other. They're calling each other names of the worst kind. I mean, you call yourself a mature democracy or the largest democracy. Yes, largest it is, but it doesn't seem to be that mature the way things are going. And people are taking, as if it's all free for all. There is a law of the jungle. Everybody has the right to say anything. But please remember, as far back as 1860, the law was made that, if you demolish somebody's reputation or character, which jolly well takes more than half a lifetime to build in a space of few seconds, because what you say is carried across the internet to millions of users, millions of listeners on social media. So the most important thing is, the more the responsibility, the more the introspection. Now here is a person who is in charge of a big political party, whose utterings and whose voice is heard across the nation and across the world. When you make such scandalous allegations which have no basis, there is no doubt as to what the accused meant, Mr. Gandhi meant. He meant to attack the Prime Minister, who had nothing to do with the two other persons that he named, Nirav Modi and that Lalit Modi, except that they shared a common surname. I mean, there are 10 crore people who share a surname called Modi. There may be 10 crore Sharmas, there may be 5 crore Kapoors, there may be 2 crore Sethis, whatever. But here the allegation was made by a high political functionary against a high political functionary, which was a completely below the belt by saying, well, you are a Modi,
Okay.
they are Modi, are all Modi's
Okay.
chores. I mean, there's no doubt about it. So I want to end by saying this should be a beacon judgment. Everybody should look at it and look
Okay.
and feel that if we are going to say all this, this might happen to us. I think it's a judgment which is required
Okay.
in the current laws that we are facing.
Mr. Rohatgi, the sentence is by the book, the suspension is by the law. I understand that no rules were broken, no laws were broken. But there is the law, and then there is the spirit of the law. As a seasoned legal luminary, do you think the punishment by the Surat court and the haste with which Mr. Gandhi was suspended by the speaker was appropriate? If the Surat court has given Rahul Gandhi 1 month's time to appeal, where was the need to rush to suspend him, sir?
Sorry. I again tell you, Shreya, the effect of the Secretary General's letter is nothing. It's zero. It has no meaning. You can throw it away. The suspension or the disqualification applied the moment the judge passed the judgment. This is what I've been trying to say on TV for the last 4 hours on different channels. You do not require what was done by the So that's the law. It happens. There are some laws in contradistinction, which say that this will take effect if such and such person passes an order or is authenticated by the governor or a gazette notification is issued. Then, it takes effect. There are laws of that type also. But here the law is, it takes effect automatically. If it does, it does. What can be done about it? Either change the law. Don't blame the parliament or the secretary.
I understand that. I understand that. But let me ask you again a question on the hastiness. And I ask you this question in the backdrop of what has happened with Lakshadweep's MP Mohammad Faisal. He's sentenced to 10 years in prison for attempt to murder. He's disqualified immediately. It's as per law. The EC then orders a bypoll as per law. And then the Kerala High Court stays its sentencing and the Supreme Court cancels the bypoll. So he's back to being an MP. Of course, a different matter that the Lok Sabha Secretariat is not allowing him to enter.
So no, Shreya, very, very simply, we do it every day. This is not the first time this has happened. Every day this is done. The least that was required of Mr. Gandhi with a vast, material and talent of legal binds with them. All they required was they should have filed an appeal yesterday to be taken up at 4 o'clock before the appellate court. They should have requested for a stay, or should have done it today. They can do it tomorrow. The election commission is not going to act in the next 10-15 days because it takes time for them to assess the situation and then issue a notification and then actually conduct an election. In the case of the other MP, he was sentenced to 10 years. Not easy to get a stay of that nature. He was lucky to get that stay. Now here, it may be a better chance for Mr. Gandhi to take a stay, but then he should apply for a stay. He hasn't applied for a stay. What are they waiting for? And mind you, it's very important to know that a stay which is required for him to re-enter parliament is a stay of the conviction. That is stay of the finding of guilt and not merely a stay of 2 years. That's very important. But then what are they waiting for? You should do it. If they get a stay, things are hunky-dory. If they don't, they don't. And every day, I have done hundreds of cases where people are disqualified from different houses on account of different problems like corrupt practice, this, that, so many things. We go to the Supreme Court. Many times you do not get a stay of conviction. You get what is called a partial stay, which in lawyers' language is called the Indira Gandhi stay. The kind of stay Indira Gandhi got in 1975. That was a stay which said that she can go into parliament, she can take part, but she can't vote. Things like that. All that is a matter which will happen later. But then don't blame. If you blame the law, then you should challenge the law. Law is not under challenge.